Hi everyone, today's session is the unit is Contract Law 3.28 and today we'll be doing Learning Outcome 2. Yesterday we did Learning Outcome 1, which was to understand the elements of a contract law and the key principles. We looked at what offer is, what acceptance is, and we looked at the terms of a contract. We looked at the formation of a contract. Today we're going to be looking at understanding the key elements of a binding contract. So the learning outcomes are to distinguish between an offer and invitation to treat, to explain the issues regarding the postal rule, to look at the consideration and the rules for consideration and the tests of enforceability. So 2.1, to distinguish between an offer and invitation to treat. So what is an offer? An offer is a statement of terms which the client, which is the offerer, is prepared to be contractually bound by. The offer must be complete, specific, and capable of being accepted. It must include the fundamental terms of the agreement with the intention that no further negotiations are to take place. The client offer contractor the work, and therefore the contractor must carry out the work under the client's terms and conditions. It is possible to make a conditional offer. The effect of this is that an offer cannot be accepted if the condition has not been satisfied. For example, the client requires the contractor to have a specific tool or machine before an offer can be made. An offer is essentially a proposal made with the intention that if accepted by the person to whom it is addressed, which is the offeree, the person making the offer, which is the offerer, intends to be contractually bound by it. Whether the offer is made with requisite intention, intention is assessed objectively. Accordingly, the offerer will be bound if his words or conduct are such as to induce a reasonable person to believe that he intends to be bound, even if in fact he has no such intention. Termination of an offer. An offer may be terminated or revoked if the offer is withdrawn or revoked at any time prior to the acceptance, provided that there has been communication between the client and the contractor. The client making the offer dies, or failure of a condition, and a reasonable period of time has lapsed, or a time limit is specified on the offer. What constitutes a reasonable period depends on all the circumstances of the case. If, on the other hand, the offer stipulates a time limit within which acceptance must occur, the offer will cease to be open for acceptance once that time limit has expired. If an offer expressly provides that it is to determine on the happening of a prescribed condition or a particular event, it cannot be accepted once that condition or event has been satisfied. Similarly, an offer may be construed as being subject to an implied condition. For example, an offer made at auction ceases when the higher bidder is made. And an example of this is the case of Harvey and Farsi, 1893, where Harvey sent a telegram, excuse me, Harvey sent a telegram to Farsi which stated, "Will you sell us bumper hall pen? Telegraph lowest cash price paid." Farsi replied by telegram, "Lowest price for bumper hall pen is £900. Harvey then replied, "We agree to buy bumper hall pen for the sum of £900 asked by you. Please send us your title deed in order that we may get early possession." And it was held in this case that the Privy Council held that there was no contract concluded between the parties. Facey had not directly answered the first question as to whether they would sell, and the lowest price stated was merely responding to a request for information, not an offer. There was thus no evidence of intention that the telegram sent by Facey was to be an offer. Another case in regards to termination of an offer is the case of Carlisle and Carbolic Smoke Ball Company, 1893. In this case, a newspaper advert placed by the defendant stated £100 reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the influenza after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. £1,000 is deposited with Alliance Bank, showing out sincerity in the matter. Mrs. Carlisle purchased some smoke balls and used them according to the directions and caught flu. She sought to claim the stated £100 reward. The defendant raised the following arguments to demonstrate that advertisement was a mere invitation to treat rather than an offer. The advert was a sales puff and lacked intent to be an offer. It is not possible to make an offer to the world. There was no notification of acceptance, and the wording was too vague to constitute an offer, since there was no stated time limit as to the catching of the flu. There was no consideration provided, since the offer did not specify that the user of the balls must have purchased them. Acceptance. A fully binding contract is only formed if an offer is accepted. Acceptance is a final and unqualified acceptance of all the terms of the offer. The offer must be accepted without introducing any new terms. Acceptance does not take place until communicated to the client making the offer, and communication of the acceptance is the moment when the contract is formed, and the acceptance must be in the form of designated by the client. The terms in which the offer is made and accepted also correspond. Accordingly, if a response to an offer seeks to vary a term to introduce a new term, it will not constitute an offer, as I've just stated earlier, but rather a counter offer. And a counter offer has the effect of extinguishing the original offer, which the original offerer can either accept or reject. And a case in regard to acceptance is the case of Entories against Miles Far East, 1955. In this case, the claimant sent a telex message from England offering to purchase 100 tons of cathodes from the defendants in Holland. The defendant sent back a telex from Holland to the London office accepting that offer. The question for the court was at what point the contract came into existence. If the acceptance was effective from the time the telex was sent, the contract was made in Holland and Dutch law would apply. If the acceptance took place when the telex was received in London, then the contract would be governed by English law. It was held in this case to amount to an effective acceptance. An acceptance needed to be communicated to the offeree. Therefore, the contract was made in England. Another case in regards to acceptance is the case of Brogden and Metropolitan Railway, 1977. In this case, the claimants were the suppliers of coal to the defendant railway company. They had been dealing for some years on an informal basis with no written contract. The parties agreed that it would be wise to have a formal contract written. The defendant drew up a draft contract and sent it to the claimant. The claimant made some minor amendments and filled in some blanks and sent it back to the defendant. The defendant then simply filed the document and never communicated their acceptance to the contract. Throughout this period, the claimants continued to supply the coal. Subsequently, a dispute arose and it was questioned whether in fact the written agreement was valid. It was held that the written contract was valid despite no communication of acceptance. The acceptance took place by performing the contract without any objection as to the terms. Now we're going to look at what is invitation to treat. So invitation to treat is different to an offer, as it only invites the party to make an offer and it is not intended to be binding. The contractors are invited to bid on the job by calculating the total work cost and to have the tenders submitted in a specified time. The main difference between this situation and an auction is that a person submitted the tender does so in ignorance of others' bids because the final decision is up to the client. So the difference between an offer and invitation to treat. An invitation to treat is when a client invites contractors to make him, her an offer. For example, when the client advertises a job or internet or newspaper. It is usually an invitation to treat rather than an offer. The offer only comes into existence after the client reviews the tenders handed in by the contractors and accept the offer. An offer, on the other hand, is when the client offers the job to one contractor without advertising the job or having contractors to submit in the tender. Making an invitation to treat rather than offer protects the client from finding him herself agreed into a contract he or she cannot fulfill. Instead, the client can refuse the contractor's offer for many different reasons. This can be a very important protection for the client making the offer if the advertisement for the job offers at long distance, for example, through the internet or newspaper. Always ensure that any website advertisement, etc., make it clear that it's only an invitation to treat, not an offer. So some examples of invitation to treat are invitations to treat can be anything displayed at a large number of people as long as there's no defined way to choose who can accept it. So let's go through some examples. And the first one I already mentioned was advertisements. Advertisements are typically an invitation to treat because they lack the important information that would make it an offer. An offer is made as soon as the customer approaches the seller with an offer to buy. Defining advertisements as invitations also allows sellers to refuse to sell products at mistakenly marked prices. Advertising example. An advertising, as we mentioned, is an invitation to treat because it gives the supplier representation to potential customers. So an example of an advertisement where it would be invitation to treat is, imagine if you see a product advertised at £20, that's an invitation to treat, and decide to take it up to the counter and prepared to make an offer. As invitation to treat are not binding, if the shop employee says that it's actually £30, you ain't able to demand it to be sold for £20. The next example is an auction sale, which we mentioned earlier as well. Typical auctions can also be invitations to treat. When an auctioneer puts up something for sale, they are not making an offer to sell to the highest bidder, but rather are inviting offers from the assembled bidders. When a bidder makes an offer, it can be accepted or rejected by the auctioneer. The next example is display of goods. So items on displays, such as items in a shop advertisement and catalogues, are all common examples of invitation to treat. Goods on display in a shop are invitations to treat where the shopkeeper is inviting the customer to make an offer for the goods, not an offer. The customer makes an offer for the goods which the retailer either accepts or rejects. And a case in regards to that is a Pharmaceutical Society of Great Britain against Boots 1953. In this case, Boots introduced the then new self-service system into their shops, whereby customers would pick up goods from the shelf, put them in the basket, and then take them to the cash till to pay. The Pharmaceutical Society of Great Britain brought an action to determine the legality of the system with regard to the sale of pharmaceutical products, which were required by law to be sold in the presence of a pharmacist. The court thus needed to determine where the contract came into existence, it was held that goods on the shelf constitute an invitation to treat, not an offer. A customer takes the goods to the till and then makes an offer to purchase. The shop assistant then chooses whether to accept the offer. The contract is therefore concluded at the till in the presence of a pharmacist. Another example in regards to the difference between an ITT and an offer is the famous case of Fisher and Bell, 1961. In this case, the defendant had a flick knife displayed in his shop window with a price tag on it. Statute made it a criminal offence to offer such flick knives for sale. His conviction was quashed as goods on display in shops are not offers in technical sense, but an invitation to treat. The court applied the literal rule of statutory interpretation in this. Now we're going to go to 2.2, which is to explain the issues regarding the postal rule. So postal rules are exceptions of offer and acceptance rules, defining some special problems in distant communication. Postal rules were created as an exception to the general offer and acceptance rules. In general offer and acceptance rules, an offer could be withdrawn or revoked any time before its acceptance. There are often conflicts about when the offer was accepted or revoked. Postal rules were created to solve the problematic issues between offerer and offeree. Distant communication also raised some particular issues. Post or mailing is often referred to as snail mail because it could take a longer period of time to get the recipient. This may cause some problems according to the formation and revocation of the contract. Offerers could not precisely know when the acceptance or revocation took place, as in Collins 2003. In the face-to-face situation, business parties can communicate if any questions occur, while in the environment of distant contracting or indirect business, instantaneous method of communication is not available. In this kind of situation, business parties could hardly be aware of the acceptance or refusal of a contract. Postal rule is used to solve problematic cases such as the delay of communication. Issues relating to postal rule. A traditional analysis of contract law prescribes that to be enforceable, a contract must consist of certain identifiable elements: an offer, an acceptance, an intention to create legal relations, and consideration. The problem is that until an offer or acceptance is actually received or deemed to be received, it can be retracted. So because you cannot rely on any legal rule of deemed receipt, a sender, while liaising by email on contractual or time-critical matters, needs to check the email was received, whether by requesting an acknowledgement or by calling to check. Since there are many delays and failures in situations in sending and receiving messages through emails, parties could not get instantaneous communication between each other. Postal rules should be applied to email contracts, but there are no legislative acts to decide the time and status of the emails. These rules, the postal rules, are relevant to the modern day because you can still end up making contracts via letter and post. Further, there's a general rule that acceptance occurs at the point of communication. For example, imagine you are in a Zoom call with an unreliable internet connection. If you tell the other party that you accept their offer, but your internet drops out, you will only have a valid contract when the communication actually reaches the other party. Really important case in regards to postal rules is the case of Adam and Linsell, 1818. In this case, the defendant wrote to the claimant offering to sell them some wool and asking for a reply in the course of the post. The letter was delayed in the post. On receiving the letter, he claimed the claimant posted the letter, a letter of acceptance the same day. However, due to the delay of the defendants had assumed the claimant was not interested in the wool and sold it on to a third party. The claimant sued for breach of contract. It was held in this case that there was a valid contract which came into existence the moment the letter of acceptance was placed in the post box. This case established the postal rule. This applies where post is the agreed form of communication between the parties and the letter of acceptance is correctly addressed and carries the right postage stamp. The acceptance then becomes effective when the letter is posted. Another case in regards to the postal rule is the case of Howell Securities and Hughes 1974. In this case, Dr. Hughes granted Howell Securities an option to purchase his house for £45,000. The option was to be excisable by notice in writing within 6 months. 5 days before the expiry, Howell posted a letter exercising the option. This letter was never received by Hughes. Howell sought to enforce the option relying on the postal rule stating that the acceptance took place before the expiry of the option. And it was held in this case by requiring notice in writing. Dr. Hughes had specified that he had actually received the communication and had therefore excluded the postal rule. Explain the consideration, the rules of consideration, and the test of enforceability, 2.3. So consideration. The basic rule of consideration is a promise will not be enforceable unless it is supported by consideration. Main exception to this rule is promises made under seal. A common definition is in terms of the price of a promise. For example, what one party must pay, not necessarily in financial terms, for promise of another party such that the promise becomes legally binding, for example, gives rise to a valid contract. In other words, the promise offer to be legally binding, it must seek something or some action in return. Promisee must show that they have bought the promise either by doing some act in return for it or by promising to do or refrain from doing some act in return for it. A type of bargain quid pro quo is at work here. Consideration is traditionally needed not just for a new contract to be formed, but also for making effective an agreement to vary or discharge an existing contract. Consideration need not benefit promisor. It can consist simply of some detriment to promisee or some benefit to the third party. Consideration is to be distinguished from motive or reason for contracting. Requirements for consideration to be valid. Consideration must not be present. Consideration must be given in return for, must be to some extent caused by promise or act of other party. For example, there must be fairly direct correlation between consideration and promise and an act. Something only done for reason other than promise will not be a valid consideration for promise. This requirement is often summed up by the expression consideration must not be passed. An important case that identifies the definition of consideration was the case of Curry and Meeson 1875, where it stated the definition of consideration is some right, interest, profit or benefit accruing to the one party or some forbearance, detriment, loss or responsibility given, suffered or undertaken by the other. And an example of the case that consideration must not be in the past is the case of Roscola and Thomas 1842. In this case, Roscola purchased a horse from Thomas. Thomas then promised the horse was sound. The horse was in fact not sound, and Roscola sued for breach of contract. The court said that he had no case. The only consideration he had given was passed by the time the promise was made, and the contract was merely that Thomas would deliver the horse on request. The next requirement is consideration must move from the promisee. which is the claimant. Under traditional view, consideration must be provided by promisee in order for them to be able to enforce promise. Thus, party who has not provided consideration for promise cannot enforce promise. It is only the party who has paid for the promise who can enforce it. This is the basis of the rule of privity of a contract. For example, contract between A and B for benefit of T cannot be enforced by T if T did not provide consideration for the promise concerned. For example, in the case of Tweedle and Atkinson, 1861. In this case, the facts of the case are the son and daughter of the parties involved in this dispute were getting married. As such, the father of the groom and the father of bride entered into an agreement that they would both pay sums of money to the couple. Unfortunately, the father of bride died before he paid the money to the couple, and the father of the son died before he could sue on the agreement between the parties. As a result of this, the groom brought an action against the executor of the will for the payment that has been previously agreed between the fathers. The issue in this case was that the primary issue for the court was whether or not the son could, as a third party to the agreement, enforce the contract between the fathers, which was ultimately for the benefit of him and his wife. It was argued that the intention to the agreement between the fathers was for the couple to derive a benefit from the payment of the money. Moreover, it was argued that preventing the son from being able to enforce the contract would effectively ignore the intention of the fathers. The outcome in the case was that the groom's claim was rejected by the court. It was held that the groom was not part of the agreement between the fathers, and he did not provide any consideration for the promise made by the father of the bride. Also, as a stranger to the contract, the son could not enforce it. On the basis, the court found in favour for the executor of the will. The next requirement is the consideration must be legal. Under traditional view, consideration must be provided by the promisee in order for them to be able to enforce promises. Consideration cannot be something or some act which is illegal, immoral, or contrary to the public morals. For example, in the case of Wyatt and Kreglinger and Funu, 1933. In this case, Mr. Wyatt was a manager employed by Kreglinger and Funu KF. On his retirement, they wrote to him granting him a pension of 201 per annum, providing he did not enter the wool trade or act in any way to his employer's detriment. The pension was paid for approximately 9 years, but then KF wrote to Mr. Wyatt advising if the pension was to be discontinued. Mr. Wyatt sought a declaration that KF were liable to continue to make the pension payments, and it was held that Mr. Wyatt was unsuccessful in his claim, even if the letters amounted to an agreement on the terms of the contract. Within them, such an agreement would be void as being against public policy and in restraint of trade. It would be against public policy to seek to restrict competition in this way, and any such agreement was therefore unenforceable. The next one is consideration must be requested. There must be express or implied request by promisor to promisee for consideration. It should be distinguishable from conditional gifts. Next requirement is consideration must be sufficient. Consideration must prove some benefit to the promisor or some detriment to the promisee, but benefit or detriment need not amount to much. The leading case for this is the case of Thomas and Chappell and Nestle, 1960. In Thomas and Thomas, an agreement was made that a woman was allowed to reside in a property for £1 a year. This was sufficient consideration and it was not a mere gift. The case of Chappell and Nestle, 1960. In this case, the defendants, Nestle, contracted with a company manufacturing gramophone records to buy several recordings of music. The plaintiffs, Chappell and Co., held that the copyright in these recordings. Nestle offered to sell these records at a discount price to anyone presenting 3 wrappers from their chocolate bars. The wrappers themselves were worthless. and were thrown away by Nestle. The plaintiff sought an injunction restraining the manufacturer and the sale of the records because they breached copyright. The House of Lords held in this case that the rappers did not form part of consideration for the sale of records, despite the fact that they had no intrinsic economic value in themselves. And Lord Somerville said that a contracting party can stipulate what consideration he chooses. A peppercorn does not cease to be good consideration if it is established that promisee does not like pepper and will throw away the corn. Therefore, as the wrappers had no monetary value, the sale was not covered by Section 8 of the 1956 Act, and the Lords found in favour of the defendants. Nevertheless, consideration must have some economic or material value, even if negligible. Consideration can consist solely in sentimental or otherwise emotional value. And the leading cases for this is White and Blewett, 1853, US case of Hammer and Sideway, 1861. In some cases, consideration can be provided by promise not to sue, and that was the case of the leading case in that was the case of Alliance Bank Limited and Broome, 1864. And in this case, the defendant owed an unsecured debt to the plaintiffs. When the plaintiffs asked for some security, the defendant promised to provide some goods but never produced them. When the plaintiffs tried to enforce the agreement for the security, the defendant argued that the plaintiffs had not provided any consideration. It was held that normally in such cases the bank would promise not to enforce the debt, but this was not done here. By not suing, however, the bank had showed forbearance and was valid consideration, so the agreement to provide security was binding. Consideration must be sufficient carried on. Forbearing to enforce a legal claim will only amount to a valid consideration if A, the claim is reasonable as opposed to frivolous or vexatious, B, promisee honestly believes the claim would be successful, C, the promisee has not concealed facts from promiser which would affect validity of claim, and D, the promisee evinces intention to bring proceedings if the promise not honoured. Again, parties promise not to enforce existing claim would only provide consideration if promise provided in return was actually induced by the promise not to enforce the claim. And the case in regards to that, the leading case is the case of Combe and Combe, 1951. In the facts of this case is during the divorce process, the husband promised to pay his ex-wife a tax-free sum of £100 each year to represent a permanent maintenance payment. The wife was aware that the husband was not in a good financial state and made no claim to this payment. Several years later, she brought an action to the claim the arrears that were owed under the agreement. The court held that the wife could only enforce her agreement for the payment which was promised by the husband if she had given consideration. The court found that no consideration was given by his wife as she had not agreed to apply for the maintenance that was promised by the husband. The husband did not request the wife to refrain from taking the maintenance payment, and therefore the wife could not claim for the money. Performance of an existing duty. Performance or promise of performance of an existing duty will usually not amount to consideration. The rationale is promisee suffers no legal detriment. They can already be sued to enforce original promise, and promiser only obtains that to which they were already entitled. But the courts have increasingly introduced exceptions to this rule. The three main types of existing duty: public duty. So here the person carrying out duties which they are required to do under general law, independent of the contract, will not provide consideration unless they do something extra. And the rationale around this is to discourage persons with public duties from demanding additional contractual payments or other benefits for carrying out duties. And the case for this, the leading case, is the case of Glassbrook and Glamorgan CC 1925. In this case, during a miners' strike, and mine owners were fearful of violence occurring. The assessment of the amount of police protection that they needed differed from that of the police whose job it was to provide it. Eventually, the police did not agree to amount a stationary guard, which they did not think necessary, but they did so on the basis that it would be paid for by the company. The company agreed to pay for more extensive police operation, but later refused to make the payment, claiming that the police were entitled to recover the payment as they had done more than perform their existing duty. Performance of existing duty, and the next one is existing contractual duty to promisor, traditionally found not to be consideration, and the leading case is Stilk and Myrick 1809 and Hartley and Ponsonby 1857. Basic concerns of courts here was to minimize risk of extortion and duress. So if one party is promised to perform an existing contractual duty to supply goods or services, confers an extra practical benefit on the other party, it will be sufficient consideration to make a promise given in return binding, as long as no duress is involved and the parties that are involved in genuine renegotiations of the contract. Existing contractual duty to third party. The situation here is that the A promises C that A will perform contractual obligation already owed to B. The performance of that obligation can equal good consideration for promise made by C and A. And the leading case in this is the case of Shadwell and Shadwell 1860. In this case, the defendant was the plaintiff's uncle. The uncle promised to pay his nephew £150 a year until the nephew's income reached 600 guineas, provided the nephew married his fiancée. The uncle paid 12 instalments but then died, and the payment stopped. The nephew sued his uncle's estate for the remaining payments. And the decision and the outcome in this case was that the Justice Earl said that performance of the marriage contract was consideration, even though the contract was made with the third party to the agreement, as the uncle's promise was an inducement to the nephew to perform this contract. He said that the plaintiff had, by getting married, made a material change in his position and had induced his wife to do the same. They may have incurred pecuniary liabilities that would be a loss to them if the promised income was withheld. He recognised that marriage could be a benefit to interested relatives, and so the uncle did derive a benefit from the marriage. Therefore, the marriage was good consideration. And we've finished the elements of consideration, offer, acceptance, and ITT now in regards to forming a contract. And some of the additional cases that I've not gone through, you can go through them. They're on Moodle for you to have a look at in regards to, you know, whether there was consideration or whether there wasn't consideration, but also whether the difference between an offer, invitation to treat, and also the different types of cases in relation to consideration, also in relation to what an offer is. So you could go on to Moodle for any sort of issues regarding any new additional cases. The references that have been used for this is Anson Law of Contract, Ayes Studies in Contract Law, Beale Contract Law. The pages are there for you to refer to. What have been used in today's session: Collins, The Law of Contract, Cambridge University, Nchongo, The Duress Undue Influence, and Hart, The Concept of Law. Then we've got McKendrick, Contract Law, Text, Casebooks and Materials, and McKeel, The Construction of Contracts, Partington, An Introduction to English Legal Systems, Smith, ATHE's Introduction to Law of Contract, and Wincombe, Contract Law and Practice. These will help you towards completing your assignment for Learning Outcome 2. Thank you for attending today's session.